to present enormous opportunities for addressing critical challenges in Africa, but it also noted that this raises a lot of complex legal and ethical issues. In order to harness this technology, these issues have to also be taken into consideration. That is the Freedom to Innovate report from the panel of experts headed by Callistus Juma that released the report for member states, which was presented at the AU summit that was 2007. Now, the biotechnology stands out in Africa, as I said. Today, Africa actually has a number of blueprint policy positions. One that stands out is Agenda 2063. Then I've just talked about Freedom to Innovate, which was from the Callistus Juma panel. Then we have a policy for Africa on science, technology, innovation strategy for Africa, which was between 2014 to 2024. But this year is when it was to be to achieve its desired target, but it has been lifted to still continue guiding decision making on the continent for the next 10 years. So is to be adjusted to be referred to as STIZA 2034. Now, Agenda 2063 is the vision for Africa for 50 years, which started in 2013. So, meaning from 2013 to 2063, we are focusing for the 50 years of Africa, the Africa we want. And Agenda 2063 in striding to see Africa achieve the socio-economic transformation that it desires, places science, technology, innovation as the epicenter of this agenda for African socio-economic transformation. That's very key to note. So Agenda 2063 places science, technology, innovation as the epicenter of Africa's socio-economic transformation. So member states are actually are implored to tap into this Agenda 2063, the aspirations that it lays for the Africa we want, and where possible to focus their energies more to science, technology, and innovation in order to achieve the Africa we want in the next 50 years. Now, Agenda 2063, as we can see, captured a policy blueprint. Then we also have STIZA, as you can see. These are very important documents right now, directing the agenda on science, technology, and innovation and other areas of Africa's transformation. Now, it's key to note that the tools of modern biotechnology or biotechnology from Africa's perspective has been viewed to be one that could support interventions in food security, where there can be increased crop productivity, high yields, improved products, crops with rich nutrition for all that need, either young or old. Also could be a very ideal solution to the effects meted to the planet by climate change. Also in the field of health care, has laid its feet down to observe the importance of modern biotechnology in the field of vaccines, in the field of fight against malaria, towards the development of technologies such as the gene drive. So this remains key. And very instructive to this was a position of the heads of states and governments in 2017, where the member states did take note the importance of the gene drive technology towards adding up to the tools in the box to fight malaria. Now, for that matter, the heads of states and governments implored parties to work closely, especially the organs of AU, such as the AU DNA part, to work closely with WHO, that's World Health Organization, and also in order to make sure that member states really invest in research in order to get to study and find how the gene drive technology can help so as to be added up to other existing tools in the fight against malaria. So notably also the tools of modern biotechnology in the area of environmental sustainability has been taken note of. The more reason that member states under the auspices of African Union, most cases supported by the AU DNA pad, that has taken part actively in the negotiations at the COPMOPs under the auspices of a Convention on Biological Diversity, the convention and its protocols. That clearly says or indicates the desire that Africa wants or places on this technology for purposes of having a sustainable utilization of the environment or biodiversity. So that remains key from the African point of view. Biotech regulation in Africa remains key. Now, for starters, when you talk about biotechnology, they go hand in hand with biosafety. And the reason has been said. Why? Because the novelty of techniques employed in introducing new genes and traits is the reason for that extensive debate today. And it has prompted the need to have regulations at national and international level. So that shows how important it is. Now, Africa faces a patchwork of regulations ranging from strict oversight to more biotech-friendly policies in some countries. I must note that there are countries that have very strict regulatory oversight, which sometimes actually bars prospective investment in the countries. But there are countries that have policies that are friendly. So this really calls for a proper coordinated or having an harmonious frameworks among member states so as to overcome the challenges at hand. Now, I've taken sampled examples of these regulatory frameworks for decision-making purposes. And to start with, I share with you here the flow chart of Kenya, where it provides a clear pathway of decision-making. When you see on the left of your screen, it's a point where an application is lodged, that's reflected in yellow. The PI there is the principal investigator of this event that is going to be introduced to the environment. He presents his application to the IBC, where the IBC is the Institutional Biosafety Committee. Then the Institutional Biosafety Committee reviews this application and submits it to the NBA. The NBA is the National Biosafety Authority, and where the National Biosafety Authority receives, screens for accuracy, completeness, and also sends to the experts to review, where the experts review and find that it conforms. Sometimes it calls for risk assessment, where this is provided for as the law provides, specific legal framework of a country provides. Then the application is reviewed by other designated members, also whose recommendations are considered in the final decision making. And thereafter, a decision document is prepared. It can be for approval or can be for rejection. These are all provided for in the law of the country, and to a point that the last is where the regulatory agency grants the approval, and it acts actually as the clearinghouse, you can see. So Kenya provides a very clear pathway of decision making, and it's time bound, as you can see, within a period of 90 to 150 days, where communications have to be made, and it's all captured in the legislation. So that's very important to note, that there are existing frameworks, and this flow chart facilitates clear decision-making process for a country, and which is good for all, because once this is the case, all its prospective investors, or those who desire to apply, or those who are involved in this, will know how a decision is arrived at and when. So this is how important it is. It is a very certain process, and that's that. So I can also share with you, South Africa also has South Africa has its own pathway, where it involves, it's on the left on this slide. You can see where an application is presented at some point to the registrar. The registrar screens, the office of the registrar screens. Then there's a council in the process, an executive council. That council takes the decision. Also, it invites risk assessment or an environmental impact assessment. And all this may be considered. And of course, they also can make consideration for socioeconomic impact. So at the end, where it meets the requirements and all is provided to satisfaction, then a permit is issued to the applicant in order to deploy the material into the environment, or for the purpose for which it has been applied. I also shared with you a chart for Uganda. Now, for Uganda, provides clearly, they have the national focal point, which is the Ministry of Water and Environment. The focal point acts as a conduit between the national competent authority and other arrangements in the country with the CBD. Now, the CBD is the Convention on Biological Diversity. It has a secretariat that sits in Montreal. Now, that CBD links up with the national focal point, which is the Ministry of Water and Environment. Then the processes begin also through the IBC, where an applicant can introduce through the IBC. The IBC is the Institutional Biosafety Committee. Then the application thereafter is processed. It's placed before the NBC, where the NBC actually provides technical advice, and also at the end can make decisions. And these decisions is presented to the UNCST, that's the Uganda National Council for Science and Technology, for purposes of implementation, where a permit is granted or not approved in some cases, where it has not met the required expected results that it's expected to have. Now, today in Africa, you can see the trail of biosafety regulation through this map, where you can see that the map bears colors here, very distinct colors. We have that is dark gray, we have that is orange, we have green, flat, then we have green with golden stars. Then with one exception, this is Uganda here, where you see the green is slashed with white. It explains why. Now, countries that have the dark gray that you see at the background or in this map are countries that have, in this map, reflects countries that have, they have not yet taken off in any way. So to say, probably they have no legislation, biosafety legislation, which is a requirement in the regulatory process. They do not have even CFTs. And when we talk of CFT, we mean confined field trials, so to say, where they do not conduct any trials of any material or having any trace of the law or existing legislation in their countries for that. Now, when we come to countries that are orange in color, here you see there are not many. We have Namibia, we have Zimbabwe. Though Zimbabwe has actually, Zimbabwe, we have Niger, Mali, Senegal, Cote d'Ivoire. These are countries that stand out with laws. They've gone a step forward to see that they have their national legislations in place for purposes of regulation, so to say, but they have not gone further in putting up materials, probably releasing limited releases in the environment for trials, or probably we cannot really say much. Others could be having some arrangements or some operations in their laboratories. That does not come evidently to us for us to state confidently that country X is doing this and that. But what we know, they have legislations, but not openly come up to show that they're doing work in the fields for now. Now we have one country, as I said, green but slashed with white, is a very unique case. It's a country that does not have, this is Uganda, standing out alone. It does not have an explicit legislation, just to say, but it has piecemeal arrangement. And also what they have that is allowing, facilitating the conduct of many research in the country is a legislation that provides for the role of an oversight for the Uganda National Council for Science and Technology. Now, that legislation provides the UNCST with the mandate to have an oversight on all research in the scientific research in the country. So for that matter, it has gone ahead to establish a National Biosafety Committee for purposes of making decisions where scientists present applications to conduct research in the lab, and also having probably limited environmental releases for purposes of research. So that's why it stands out, but it does not have an explicit legislation for now. What we say is work in progress, and with hope in the near future, the country will have a legislation that will enable its scientists to be able to take their research further to commercial releases. We have countries that are green flat, as you see. We have Egypt here, we have Mozambique, we have Zimbabwe, we have Cameroon, we have a number of them, as you see them, Rwanda. These are countries that have gone in place, put their legislative frameworks. And when I talk about legislative frameworks, so to say, they have the policy to guide, then they have the policy translated into legislation to have the force to bite in order to create do's and do's nots. Then they have also gone ahead to have confined field trials, and they have gone some have gone in advanced stages where they are probably now conducting what they call probably multi-locational trials, doing various states like Zimbabwe. Actually, Zimbabwe really has gone far, and this map, you'll excuse me, should have been updated. Zimbabwe, I can update that Zimbabwe has gone far, has the legislation, has the entire framework in place. It's conducting confined field trials, multi-location of various locations across the country, and that's the trials in cotton. So quite promising for the country in their journey towards having a bioeconomy. Then we have countries that are green but with golden stars. Now, these golden stars take it to another level, that these are countries that have the entire system in place, meaning they have a clear regulatory framework. They are not only conducting research, but they have gone ahead to commercialize, having the products now in the hands of farmers, or having the products out there, probably to compete with their other conventional relatives. Okay, so this is the level, and we are seeing many. We begin from down South Africa. In the neighborhood of South Africa is Eswatini, which was formerly known as Swaziland. Then we have Malawi, we have Kenya, we have Ethiopia, we have Sudan, Khartoum, we have Nigeria, we have Ghana. And I think some of you who have been following stories, I think very recently this year, we saw Ghana, I think, released the Port Buara, which I think it was a landmark, a big milestone for those prospecting to have the product out for farmers to have an option. We had Burkina Faso, Burkina Faso is one of those that really took off early enough back in the years. Probably could have stagnated, but we can't say they're out. They are still in, and they're actually making very good progress in order to come back on the map. So that is it. Yes, the status of genetic engineering laws in Africa now and adoption of crops can be seen in this chart that's taken from ISA, AfriCenter, and from my fold, which is the African Biosafety Network of Expertise, where we can see the countries that are cultivating GM crops, the number of them. Then there are countries that have completed their CFTs and have undertaken, which they have actually gone further. This really ought to be updated also. So a number of actually progress that has been made, and to those who speak about it, they will say that's positive momentum. Now that launches me to a conversation around the legal battles that are occurring on the continent, and perhaps it's important to investigate what the legal battles are so far to do with, and why, and how they are shaping Africa's biotech landscape. Now, the tension between embracing technological advancement and addressing public concern has presented one of the most significant policy challenges for governments in Africa. And this is clear because where you see today, there is a tension that comes because various interests come to play. There are those who push for the technology, and there are those who push not for the technology, they push against. So it creates the kind of tension that governments are finding it a challenge to deal with. Okay, and we have seen this in a number of countries. We've seen this in the countries that I've mentioned here. Very recently, we saw the contest in Kenya in the courts. We saw the contest in Ghana. We saw the contest in Nigeria. We saw the contest in South Africa, also in the cases that have concluded recently. So these 4 countries I've highlighted here. I'm going to speak about some of the cases that came in the courts of law, and probably speak about a few outcomes. But with my panelists who are with us here, and being drawn from all these countries, I know we have a panelist from Ghana, we have a panelist from Nigeria, Kenya. I trust they will delve deeper to make our participants to this webinar learn more about these cases and their outcome. So to say, I'll not delve so deep into what really happened. Now, the first case I must say in Ghana is a case that was filed in 2015, if I recall clearly, by the petitioners were called the Food Sovereignty Ghana. It began as one petitioner, but later on the numbers swelled based on the interest they had to these cases. Because along the way, we saw one political party joining, that's the Convention of People's Party. We saw another group called the Vegetarian Association of Ghana. They also joined. Then Gauso, Akofo, Kwa, these ones also joined. They joined the petitioners, Food Sovereignty. Then on the respondent side or the defendant side, of course, key in the mix was the Ministry of Food and Agriculture. We had the Attorney General, by virtue of it being the representative of government agencies in all matters that are brought against government. We, of course, had the NBC, then we had the NBA. Now, the situation in Ghana was at the point when Ghana was transiting from having an NBC, because by then it was by virtue of a legal instrument that created the regulatory agency. But at the point this case was being filed, it was transiting to a national biosafety authority. So the petitioners here deemed it right in their interest to have the NBA and the NBC all join. Then we had another group that expressed interest to be joined in this case for the defendants. It's an association, I think, of fishing farmers. So this case took some time. It's a case that went on almost for 10 years, forth and back, where at some point a conservative confirmatory orders were made, and at some point they were set off. And the facts were very interesting. I have my Ghanaian folks here who, if time permits, they will delve deeper into this. But so to say, an outcome of this case was that the petitioners lost this case. That I think the judgment was probably early this year or late last year or early this year. So that is about the Ghana case. Nigeria case is another very interesting one. This is a case that was brought against the NBMA, which is the National Biosafety Management Agency or Authority. The case was filed by the registered trustees of health. There are several of them, actually. They were all registered trustees, interestingly. They were about 17 in number. They filed the case against the NBMA as the first petitioner, first respondent or defendant. And then they also joined Monsanto, the multinational company, for reason that they were trying to force to have GMOs actually introduced in Nigeria. And now this case actually, the plaintiffs or the petitioners here sought several reliefs from the court, where they alleged so many interesting claims, where they were pointing at the flaws of the regulatory agency. One thing that stood out was that the decision document or the permit was even signed on a public holiday, you can imagine. So quite a lot was brought up in this case in their bid to challenge the introduction of confined field trials in maize. I thought, but the first petition was dismissed. Then the petitioners went and transformed themselves and came up again with another case, probably almost on the premise on the same cause of action. And they also lost it after some time, where the judge quite had a very, very, very interesting judgment delivered. It's worth reading. If you read that judgment, I think the judge was able to make it clear that these registered trustees who had even sought for human rights, the judge was very clear to state out that the registered trustees were not humans to say that they have to enjoy human rights. These are not actually, these are legal persons, not humans. So very, very interesting judgment. The court case in Kenya is one that quite cuts so deep. For starters, the first case in Kenya was filed in 2015. It was filed by the Kenya Small Scale Farmers Forum or Association. It came up from a statement, a public statement that was made by the then Deputy President, who is respectfully, who is now the President. And that case stalled, nothing came up. We quite recall that their bid to get a conservatory order at that time was successfully challenged. The court declined to grant the conservatory orders, but the case remained undisposed. It remained in the court until 2022, when there was a subsisting ban then, and then the government that came in, the government of the day, through its cabinet, made a pronouncement in order to lift the ban that had subsisted for over 10 years, to ban imports and so on. And when this case was filed, another actually group also filed another case. So cases were being filed, but the court, in its wisdom, thought it wise to consolidate some of these cases. Then at another curve, the Law Society of Kenya, I think, also then filed a case in another court at the countryside. Now, the court, in its wisdom, felt that case filed in the countryside be brought to the city and placed under the Land and Environment Court. And it so happened that court did not delay. It quickly had the case and disposed it of, where it was dismissed in the interest of the government and all those interested. So other cases that remained also subsequently, the court was able to hear and also dispose it of. And I'm very happy that Ellis is on this call, and I'm sure at the appointed time is going to delve deeper into what transpired in these court cases in Kenya. Now, South Africa is one that has had its share of these court battles, not now for long. They have had many cases, more than any other African, I think, country. Way back, actually, 20 years back. If you go behind along the memory lane, you'll find cases like BioWatch, where BioWatch, Monsanto, and two other companies joined the Department of Agriculture in contesting a court challenge. That case dragged on, and this case was basically about the constitutional right for accessing information. You can see where the case sought, the petitioners sought to access document that was in the hands of the regulator, which was presented by Monsanto for purposes of introducing a variety, GM, into the environment. So BioWatch went to court. They felt that they have a constitutional right to access information. Very interesting events where the court upheld their constitutional rights to access information, but the task they had was to go and they look for the information they wanted. So the ministry that is responsible, the Department of Agriculture, welcomed the decision of the court and asked the petitioners to go. They simply opened the archives for them to go. And this was a very huge collection of and that generally scared them off, if you can see, because they say, please, you want information, there you are, you look for the information you want. So that's how interesting that case was. Now, there's a recent case, which I think was a decision of the Supreme Court in the case of African Center for Biodiversity versus the Ministry of Agriculture or the Department of Agriculture, Forestry, and so on. You might have read it quite, it was awash on social media. It's dubbed to be a landmark decision. Why? They say because the African Center for Biodiversity had for long challenged the introduction of the drought-tolerant maize, which is also a crop what is supposed to be introduced. It provides traits that can deal with very limited, actually with limited rainfall, especially in spells where the rains in some countries don't do much. So the idea of this particular variety was to be introduced in some African countries as pilot or for trials. I think was to be in Tanzania, was Kenya, Uganda, Ethiopia, South Africa, I think possibly even Mozambique. So BioCenter made an attempt to challenge the decision-making process, which, as I earlier showed you, the flowchart of South Africa is an application is presented to the registrar. Then there's an executive council that normally reviews with the support of the scientific advisory committee. Then a decision is made. So there was forth and back when the center challenged that decision of the decision of the executive council, the regulator. The first challenge was unsuccessful. Then they made a second challenge, which came to challenge in the High Court, and the High Court upheld the decision of the Executive Council, which is the regulator, meaning these crops were not a danger in any way to the environment or biodiversity. Now, interestingly, the petitioners did not give up their challenge, their contest. They sought the last appeal to the Supreme Court of South Africa. And I think it was about a month ago that the Supreme Court overturned the decision, annulled the decision of the High Court and also the Executive Council. And for that matter, it referred the application that was all along granted for the introduction of this particular crop, this drought-tolerant maize, to be entertained again, okay, by the Executive Council. And the emphasis the Supreme Court had was looking at the precautionary principle in this case, where the precautionary principle, we all know, is emphasized in the Convention on Biological Diversity, and also the Cartagena Protocol has taken it as its preamble. So in the view of the Supreme Court in this South African case, that the Executive Council in its decision-making did not actually evaluate the application critically, being guided the precautionary approach or precautionary principle. So that basically it was the issue that handed the decision in the interest of in favor of African Center for Biodiversity, which in my view it is always a regulatory process. Meaning, if you're a regulator, you should abide by the due process, why you should, and you receive, you review, and where you are supposed to put ABCs in place in your decision-making process. That should always be clear in order to be convincing, and not always to be seen but to do, but you should be seen to be doing the right thing. For starters, it's important to note that these cases come up, and they are not going. This is not going to be the last. Today, we hear that all the cases so far that are active have been disposed of. We learned that the one in Ghana was disposed of, the one in Nigeria was disposed of, the one in Kenya has been disposed of, the one that is in South Africa, either way, also it has been. But this is not the last. Cases are always bound to occur because today, as we speak, it's become interesting that contentions have ceased to be entertained in the public space, especially where policy contradictions will meet and this resolve where and what pathway to take as a country or as a group. Today, you find that more and more contention around policy aspects end up in courts of law. Because it's found out courts of law can be the best determinant or give the right outcome, which will sort out. So that's quite important. So we should take note that for our participants on this call, if you're a regulator, that always be prepared that questions on precautionary principle will always come up, and we've seen in the case of South Africa. So its application in decision making is always key. Aspects on risk assessment will always come up. Petitioners take interest in looking at whether risk assessment was done properly or environmental impact assessment was done. And in some countries, I think we all know processes are stalled because there's a demand to have an environmental impact assessment. There is also contention around public participation. I think we all recall in Kenya where this is where actually where the matters locked up. There were the petitioners in some angles actually tried to state that the public participation that is desired as provided under law was not discharged as it's required. So that is always part of contention. You will come to note that fundamental human rights will always be there, especially where the Bill of Rights states that some of these rights have to be adhered to as provided in the grand norm. And when I say the grand norm means the Constitution. Okay, that's very key. And I gave you an example of the case of BioWatch, the BioWatch case in South Africa, where they sought their constitutional right, the right to access information. There are also questions around administrative flaws. Now, I'll really emphasize this. If you are a regulator, abide by the administrative protocol that is in place. Any flaw can become a very, very, very critical issue, especially when disputes end up in court. Also, the challenges of trades, the improved varieties has become an issue, especially this case of South Africa, where you can see the African Center for Biodiversity simply challenged that the drought-tolerant maize variety was something to them was a hoax, actually in their witness or evidence, they presented expert evidence to challenge that, and they felt the expert witnesses' testimony was not entertained by the Executive Council, so that is the point. So there are also issues around socioeconomics will always come up, so you should watch out. You should know when to apply socioeconomic lenses, when and how. Does it inform the decision-making process? Is it scientific? Is it applied in risk assessment, or it actually blends the decision-making process at the end? So as a regulator, in whatever capacity, you should know that these are issues that come up. Expert opinion issues will come, ethical issues will come, constitutionality aspects will come, access to information will always come, so you will know how to do all that. So now that launches me to question, why are there barriers to biotechnology adoption in Africa? Now, the interplay between ethics, economy, and politics make biotech adoption a complex issue in Africa. Very complex. You find other groups talk about ethical issues. They question the ethics behind some of the material products. Economy is very tight. A number of products are not within. They are not homegrown. They always come from elsewhere, and you find even the technologies come from elsewhere. So issues around technology, yes, that really becomes key. So say the barriers, the influence, advocacy, as I already said, advocacy has become key. So how do we navigate around some of these future legal challenges? With clear biosafety regulation and framework in Africa, Africa can harness the potential of biotechnology while safeguarding its people and the ecosystem. Yes, thank you. I'm about to conclude. Yes. Policy is key. It's always desired that a good legislative framework or legal framework should have policy, should have the legislation that implements the policy, then the implementing regulations, an administrative system where you have the regulator, the decision maker, then also there should be adequate infrastructure and capacity for personnel. Yeah. You know very well, strategies for improving biosafety framework are very key. In nations, the role of public education is key. We have to inform the public so that they're able to embrace its technology. Keeping them in the dark will not be a solution. We should also encourage homegrown biotech innovations to reduce dependency on imports. Ladies and gentlemen, I thank you for listening to me. I hope I've been clear and audible. I'll wait to hear from you. Thank you very much. Merci.
Thank you so much, Sunday, for that elaborative presentation. And there's a lot to take away with us. I think issues to do with risk assessment, precautionary principle, also issues of evaluation when it comes to risk assessment, and also just to ensure that there is no tension between those pushing for the technology and those that are pushing against. Maybe an engagement would be one of the best ways in terms of reaching an amicable position. This time we will take one question. If there's anyone with a question, we can take that question. Otherwise, we have the chat platform where you can send your questions, and then we will be able to pick them, and we'll be able to respond to you. This wonderful team that we have here will be able to provide answers. I see there's no question in the chat, and no one has lifted a hand so far. Maybe we can go to the next step on the program, and then we'll be able to come back to the questions. At this point, allow me to introduce one of the other presenters. She's a principal state counsel with the Office of the Attorney General in Ghana. She holds a master in law, and was part of a team that presented the state in civil suits in relation to BioSafety Act in Ghana. Her journey with BioSafety and biotechnology started in 2015 when, together with her colleagues, they had to represent the state in a suit about GMOs and its legal implications for the states. After 9 years of litigation, the claims against the state were dismissed with the court holding that there was no breach of the BioSafety Act in Ghana. Allow me to invite Vivian Opoko. I hope I pronounced it right. Vivian, please do come forth with your presentation.
Thank you, Madam Chair. I think you pronounced the name correctly. And good afternoon to you, Chair, and the fellow panelists, as well as participants. It is great to be here. And I think, thank you so much, Akile, for your presentation. I think you took most of the things I was going to say, and you introduced the Ghana case. So you have made the job easier. You were also part of us and the journey we had through this case, through the whole 9 years and more. So you were on point.
Hello, Vivian, are you there? Seems we have lost Vivian. Maybe we can take a question for Sunday as Vivian is trying to get back. So there is a question from in the chat box. How can regulatory bodies capacitate themselves to reduce litigation? This question is for you, Sunday. Maybe you can respond as we wait for Vivian.
Madam Chair.
Great. Hi, Vivian.
Yes, I went off. I was dropped.
Okay, you're welcome back then. We will take the question later. Please go ahead.
With the question or the presentation? Madam Chair. Hello. Okay.
You can go ahead with your presentation.
Okay. Thank you so much. So as I said, Akile had already started off. The case started in 2015. That is the Ghana case. And it started with 2 plaintiffs. At the end of the matter, we had 5 and then 4 defendants. The main matter was about the regulators being, the plaintiffs were challenging, sorry, my internet. The plaintiffs were challenging the work of the regulators. Their main issue has to do with the compliance, non-compliance, according to them, with the Biosafety Act of Ghana. They said that the regulators refuse to follow the processes that have been laid down in our law, the Biosafety Act of Ghana, in approving GMO products onto the market. That was the main case they were coming against. So, as usual, when we have cases like this, you need to talk to the regulators because the Attorney General represents the regulators, but we are not the regulators. So we got the information from them and asked them, what is the situation on the ground? And we were told that indeed, the plaintiffs have actually got the processes wrong. The authority in place at that time were not regulating, were not approving a release onto any commercial market of GMO product. They were in a process of certifying a company to do a scientific research. So that was the case before the court. And initially when we saw it, we said, this is a very simple case. It's about regulations. Has it been done? Has it not been done? So we should not take long in disposing of this case. Unfortunately for us, I think the plaintiffs, they have their own issue. They have their own plan, I should say. And the case traveled for over 9 years, going before 5 judges in the High Court, and some applications even going in before the Court of Appeal. and one went into the Supreme Court, which was initially, it later withdrawn. So we were asked to come back, but in between the trial, the plaintiff filed several applications, interim applications for injunctions, about 3. And we defended all that, and they were thrown out. Eventually, we had the opportunity to go through this matter well, because as I said, we thought it was just a regulation issue. And dealing with what the law says and what the regulator has done or failed to do was supposed to be a very simple thing, but no. The plaintiff eventually brought some witnesses of scientific nature, but mind you, when they filed the suit, they were not complaining about the technology at all. They were not complaining about the science. They were like, the Ghana has in place a law. So the question was, has the law been followed or not? But they decided to take us on a wild goose chase, I should say, and was important for the lawyers defending these matters to have an idea of what is the science behind the technology. Fortunately, we had a lot of support from our partners and the regulators who took the lawyers through, and then we were able to handle this matter with some science background. And that brings me to one important thing that we learned from this case, that it is important to be able to even address the facts that were raised in this matter. We had to have an idea of what this whole technology was about. Even if it has to be basic idea, we needed to know. And that knowledge that we went through eventually helped us to address this particular issue before the court. And at the end of it all, I should say that we were able to do so successfully. The second matter too, I wanted to say in regards to this matter was the knowledge that the lawyers need. It's not only the lawyers, the judges too were supposed to have an idea of what this whole technology was about. Because mind you, the Ghana case at a point, it became quite emotional on the side of the plaintiffs anyway. They would get to court and they would throw all kinds of wild allegations out there. And they also had the media with them, and they would try to tag the motions along. You know, this particular technology invokes a lot of motions. But our line of argument was also always that the law is there, the facts are there. Every court will look at your fact and check whether it's in line with the law that has been put in place for us. So that is where we went about it. And in explaining our fact to the court, we needed to also let the court understand what this technology is about, so that they will not think that it's just what the plaintiff is telling them. And we had a lot of support from our regulators, and it ended us in a very bright place that we found ourselves after 9 years of going through this matter. For the challenges on this particular case, I would say that our main problem was initially the know-how, the knowledge, to be able to transfer it across and let the judges also see what we are talking about. And fortunately, we were able to surmount it. But going forward, we were supposed to have in place a core team or some other lawyers together, because as Akile said, this is just the beginning. The more Ghana is developing in these processes, and the more approvals that are coming in place, we have to be ready to have in place a team that will be able to defend these actions as well. And that is what I would say was one crucial thing for us. And the second thing too has to do with our regulators, because as I said, the Attorney General is the lawyer for the regulators, but we are not the regulators. To be able to do a good job when these matters get us into court, we should have in place a system that has been followed, because already we have the laws there. All that we need our regulators to do for us is to follow the law to the letter. Because if you, like the South African case that was just mentioned, I haven't read through all, but my understanding is that it has to do with the regulators not going through the regulation according to the letter. And any court, if you take a matter to the court and you haven't followed the due process that has been laid down, no court will agree with you. So one fortunate thing that we have in the Ghana case was that our regulators had gone through the processes. So when we took their fact and then we check the law. We ticked every box, and we were able to go through. So we were not really perturbed. The only thing we had to deal with was the emotional part on how the plaintiffs were spinning the argument and moving forward. But as I said, eventually, if you go to court, it is your fact and your law, and the judges saw through for us, and then we are where we are today. Madam Chair, that is the Ghana case in a nutshell.
Wow, thank you so much for that presentation, Vivian. And we also have a lot to learn from here. And as regulators, they need to follow the law. Maybe before we go to the next presenter, we can take one or two questions that were posted on the platform. So the first question, sorry, let me just access the questions. So the question, came from Esther saying, thank you for this great presentation. You have rightly noted that among the areas of contention featured in litigations include environmental impact assessment. Very true. How do we solve this problem of EIA? Sunday.
And
maybe,
okay, thank
as
you.
you think about that, there's also the other one. How can regulatory bodies capacitate themselves to reduce litigation? This had been addressed to Sunday, but I think even Vivian can also come through after Sunday. Thank you.
Thank you very much. Thank you for the questions that we've received. Vivian, for your talk. The first question, how do we solve the issues around environmental impact assessment? Now, environmental impact assessment and environmental risk assessment or risk assessment are quite maybe close, but they're different, and the demands are quite different. I think how risk assessment is arrived at is clearly laid out under the Cartagena Protocol. It lays out on how you can arrive and determine the risk assessment. And nations that have legislation, explicit legislations, have put that clearly, and some have actually referenced the Cartagena Protocol model that is provided under Annex 3 to be one that guides them in the decision-making processes. But however, there are countries that have gone further under the national legislations for the governance of environment or the management of environment that provide that for any material to be introduced, which probably has a biohazardous and so on and so forth into the environment or biodiversity, there should be an EIA conducted. Now, this has tended to present a conflict, because when we talk of biosafety, when we talk of introduction of GMOs, ideally should be risk assessment. But because there's this conflict which is not resolved in some jurisdictions, it has presented a challenge. Should it be an EIA? Should it be a risk assessment, which ideally should be scientific? Because when you talk of EIA, it presents quite a lot of things, a lot of yardsticks for measuring this. So this conflict is there, and there are countries that have veered around it. Their decision-making processes for biosafety, they don't invite it, but we know it has presented challenges in some countries where they are at crossroads on where and how to deal with it. So this is where now I think there has to be clarity in order to arrive at this. You find in some countries risk assessment is done. Then ultimately, after the decision making, you find there's a demand for also EIA to be done, to be conducted. I think that has presented a challenge. I can only say that. But it can all be cured by having a very clear script in the legislation. Once it's clearly written and provided for in a piece of legislation, then it's solved It's a matter. The second question is, how does regulators capacitate themselves? Thank you, Esther, for that first question on EIA. The second question is from Andrew Chigundu. How does regulators capacitate themselves to reduce court cases? Now, yes, Vivian said something very important and actually echoed what I said. You should not expect that the cases will stop. Out there, it's quite a challenging one. You find litigations can be conceived in any way. There are people, it's their business to always be in court. They don't care, they don't mind. It actually pays them to be in court. So you'll find they will always run to court. Whether they have a cause of action, nothing, they can be in court. So regulators should be on top of their game. I think the caution that Vivian gave was very, very instrumental. I think very instructive. You should abide by the do's and do's nots, where you add your own processes in the decision making to Lawrence, it can be challenged, can draw a lot of challenge. So capacitate yourself regularly by having legal folks around you, where possibly if there are decision documents to be prepared, let the legal mind be part of it. If there are permits to be issued, because when permits are going to be issued, they are bound to have conditions, terms and conditions. So let it be prepared by a lawyer so that you can avoid challenges in court and also can be enforced. But trainings can always come for regulators. You can familiarize yourselves with what happens in courts of law so that you are not taken by advice. I'm very happy that on this panel we have one senior member called the regulator, I should say, Eric Okore. He had his experience in that case of Vivian's talked about in Ghana. I think he's going to be a very great asset to Ghana. And that was a very good show of talent in court. So that's what regulators should do. Now, for regulators, if you are able to do things the right way, you're able to defend any matter that comes in court in the position of being a witness. So with that, I end there. Maybe I can say that. Thank you.
Thank you, Chair. If I can just add a little to what Akile said.
Please go ahead briefly. Please go ahead.
Okay. The issue of regulators is being able to defend their action. We cannot overstate that. And it is important that they comply with the laws that has been set for them. You mentioned a regulator from Ghana, Mr. Corey, who is also a panelist here. I can tell you that he was one of the witnesses we had to put in the box at the trial, the Ghana case. But because he had done his work well, he was abreast with the concept around this whole technology and what they had done. He was a very good witness for us. And even if you look at the judgment, at a point, the judge even mentioned some of his comment that he gave in the courtroom. So the capacity building and knowing what you are doing as a regulator, we cannot emphasize it more enough. It helps when we get into court that if you have done the right thing, we're able to defend the action. Thank you.
Thank you, Vivian. And we can still continue sending the questions in the chat. I'm being told the chat is not accessible. We will try to make it accessible. You can still jot down your questions, and I'm sure before the end of the session, we will be able to get those questions. Allow me now to introduce one of our distinguished litigators at a firm called G&A Advocates, who has expertise in dispute resolution across various areas of law, including commercial litigation, public law, and biotechnology law. He holds a Bachelor of Law, honors from Moi University, and a postgraduate diploma of law from the Kenyan School of Law. As a recognized authority in biotechnology in Kenya, this presenter has been part of a team of advocates that played a pivotal role in defending the government of Kenya in landmark petitions challenging the decisions to lift the ban on the importation and cultivation of genetically modified organisms. Beyond litigation, he provides strategic counsel on commercial agreement within the biotechnology sector, including product licensing and procedure compliance. In the regulatory arena, he has also been part of a team trusted to advise several key regulatory agencies in Kenya, including the Pharmacy and the Poisons Board and the Judicial Service Commission, among others. His work in his capacity underscores his commitment to advancing robust governance and compliance framework. He has also been instrumental in high-stakes legal disputes, including the 2022 presidential election petition, defending a state corporation in a multi-billion shilling construction dispute, representing a multinational telecom company in a case valued at over 300 billion Kenyan shillings, and successfully defending Kenya's Judicial Service Commission in a case contesting the recruitment of the Chief Justice and the Supreme Court. Driven by a passion of corporate social responsibility, this presenter founded and serves as chairperson of the CMR Africa, a non-profit organization led by young lawyers. Under his leadership, CMR Africa is committed to building the capacity of legal practitioners in emerging practice areas such as biotechnology law, climate change justice, and environmental law. Through this initiative, this presenter seeks to empower communities by fostering legal awareness and advocacy. Allow me to present Elias Odiambo Ouma. Elias, please go ahead with your presentation. Thank you.
Yes. Thank you, Sandra. And also thank you to co-panelists who've come before me. I must note that much has been explained, especially with regards to the intersection of science and law. Particularly, I must point out the presentation made by Senior Akile, and even the presenters noting the specific biotech development, legal development in various countries, including Ghana. Now, just to contextualize the theme of today's topic, that is navigating the legal frontiers in Africa, contemporary cases and challenges in modern biotechnology. I must note that with the background and the specific explanations made by Mr. Akile, it will only be fair that I delve now on the cases that have so far been filed in Kenya, that we've been part and parcel of the team that defended the government of Kenya, so that I give with specific context the various legal issues that have always emanated, and then give the challenges that we endeavor to encounter in this intersection of science and law, especially with regards to biotech, and then maybe give opportunities or solutions to circumvent any further developments in this arena. Now, to begin with, I must note that even as we gather here today, we must delve into the intricate intersection of science and law, and we must acknowledge the dual-edged nature of the legal disputes that have so far been filed across Africa with regards to biotech, particularly in relation to genetically modified organisms. And why do I say this? On the one hand, the courts act as torpedoes, occasionally targeting the very essence of scientific advancements by stalling or discrediting critical innovations. On the other hand, they also serve as a catalyst inadvertently or otherwise to fuel misinformation and false narratives, particularly with regards to GMOs. So you find that courts are used by those who are not for GMOs to first catalyze the misinformation narrative that is available in the social media and all stakes, and also use courts to actually legitimize these their false narratives that are are propagated in our social media. So why is this important? Because this is what informs why most of the cases that were filed in Kenya were anchored on various false negatives by non-profit organizations that are against GMOs. Particularly in the constitutional courts, there were multiple petitions that primarily challenged a lift of ban on GMOs that was issued by the cabinet sometimes in 3rd October 2022. But before I get there, I think I also need to explain to you the history that led to the cabinet memo on 3rd October 2022. Now, sometimes in 2012, the government imposed a ban on cultivation and importation of GMOs. And then shortly after, there was a recommendation of a task force that was supposed to do research on the viability of importation and cultivation of GMOs in the country. And a report was issued by the task force, but that report was never made public. And then following that report, sometimes in 2015, the current president, who was then the deputy president, made a political statement that the government will be lifting the ban that was imposed in 2012. And then that triggered a petition, because Kenya is a very litigious state. Even when government officer make a statement, that statement can always be challenged. Our constitution is quite robust. It allows filings of petitions in constitutional courts, even in non-deserving petitions. So shortly after there was a petition, that petition was never determined until 2022 when a constitutional petition was filed. But before I get there, I also need to note that on 2019, the government allowed the cultivation of BT cotton. And then come 2022, there was that lift of ban that was initially issued or imposed sometimes in 2012. Now, the moment the government lifted the ban in 2022, multiple petitions were filed both in environmental court and constitutional court. And I want to at least distinguish these petitions, and then also in 3 cadres. Number one, in as a public litigation in constitutional court, and then number 2, as also a public litigation in environmental court, then make a case for potential future private litigations against companies that are operating on GMOs. So to begin with cases that involved constitutional court, there were multiple. There were more than 5, and then there was a case for consolidation. And when the case was filed, the judge then, because of the narratives, the false narratives on GMOs, issued conservatory orders to stop implementation of the cabinet decision to lift the 2012 ban. And then shortly after, we appealed that decision, and the Court of Appeal also did not allow our appeal. But critical to note is what was the issues, or what were the issues in the constitutional petition in the constitutional court. The petitioners were primarily weaponizing the public participation provisions, noting that the alleged cabinet lifting of cabinet decision without public participation amounted to constitutional violation of constitutional edicts under Article 10, which provides for public participation. And then they also alleged that the blanket lift of the cabinet ban amounted to removal of the regulatory barriers, such that now individuals could just import and cultivate GMOs without taking into consideration the regulatory parameters prescribed under the National Biosafety Act and other enabling provisions. They also they also noted that the alleged blanket lifting of the 2012 ban amounted to violation of access to information, access to adequate food with reasonable standards, and then access to consumer protection, and so on and so forth. Now, in our view, we noted that these clandestine allegations were primarily anchored on assumption that the alleged lifting of the ban amounted to removal of the entire regulatory framework that regulates how GMOs are imported and cultivated in our country, which was not the case. So we made a case, considering that we are an adversarial system, we made a case to court that, number one, Kenya has a comprehensive framework within which for you to import or cultivate, you must satisfy. And then number two, we made a case that these being statutory frameworks, a cabinet decision cannot repeal an existing statutory legislation that has been established by the parliamentarians. And then that narrative is what we took to environmental court, a case which stemmed from alleged environmental violations. And because we were now at the Court of Appeal and environmental court matter was coming up, we decided to fast track the environmental court, made a case for fast tracking of the environmental court case, and made the same arguments in the environmental court, and the court agreed with us and made various pronouncements that actually informed the ultimate decision of the Constitutional Court. Specifically, in environmental court, the court made a pronouncement that indeed there exists a comprehensive framework that governs importation and cultivation of GMOs, and then that comprehensive framework has agencies or multi-sectoral agencies such as public health units, National Biosafety Authority, which are required to work in unity to ensure that the safety of animal and human life with respect to GMOs. Now, following that judgment, we came back to Constitutional Court and say, to the extent that these questions are the same addressed by Environmental Court, then the issue should be res judicata. And Constitutional Court agreed with us. Now, what are then the challenges that we face going forward? Satunoi, could you please mute? All right. So what are then the challenges that we are likely to face going forward? And number one, going forward, we face a situation where we'll not be dealing with public litigation, considering that as a country, we now have a binding pronouncement that at the very least has not been stayed and covers or answers all the constitutional issues that were raised in various courts. What we are likely to have is civil suits targeting companies that are either importing or doing field experiments to ensure that their products are released in the market. And as a challenge, the opportunities that then we must ensure is that we ensure compliances with regards to the processes of release of products into the market, and even processes to ensure that the agencies mandated to ensure compliance, the certificates needed, the licenses needed are actually satisfied by those agencies. And then it is also important that going forward, the regulatory authority also ensure that all their regulations are in order based on pressing social needs or pressing issues that might come up with regards to GMOs. And then lastly, we also need Mr. Sunday noted, we need intergovernmental relations and intergovernmental relations, especially with regards to sharing of data. And this is critical. Why? Because if you look at the time needed for us to release products in the market, and new products in the market, if you follow the processes, you find you'll get up to 7 years or so for a product to be released based on the experiments by various agencies, including CALRO, National Biosafety Authority, and so on and so forth. So we also need to ensure that data that has been issued in OECD countries can be transported for purposes of adoption by countries based on experiences from those other countries. So there's need for intergovernmental relations, especially spearheaded by NEPAD and other agencies, so that as far as science remains an active issue, then we cannot act as a torpedo through legal processes to ensure food safety, among other benefits that come with it. I hope that explains the position in the Kenyan context, especially with regards to contemporary cases that we are dealing with. And it also answers the challenges and opportunities for those who are involved in the market. Thank you, unless there's any question.
Thank you so much, Elias, for the great presentation. I think we'll go straight into the last presentation, then we'll take the questions. I've seen the chat has questions, the question and answer, and we will take them soon after our next presenter. So we'll get some experience now from a regulator on legal disputes around GMOs. We have a context from the Ghanaian, from Ghana. So our next presenter is the immediate former Chief Executive Officer of the National Biosafety Authority in Ghana. He has a background in environmental science with biosafety as a specialization. He started his career as an assistant director at the Ministry of Environment, Science and Technology in 1999. As the schedule officer for biodiversity and biosafety, he contributed to drafting Ghana's biosafety bill and facilitated its passage into law in 2011. He eventually became the CEO of the National Biosafety Authority in 2015 and has since been ensuring the effective running of the sector. Coaching and mentorship in biosafety skill set, both nationally and regionally, have been his passion in the recent years. He served as the resource person in several biosafety training programs in Ghana and Africa. He has been part of Africa's group of negotiators in the Conference of the Parties of the CBD. He currently represents Africa on the Bureau of the CBD Conference of the Parties. Welcome, Eric Okore. Eric, you have the platform.
Zikomo, Sandra, I hope I'm
You're
clear.
welcome.
Yeah, so again, Zikomo for giving me the floor. Good morning, good afternoon, colleagues. Let me use this opportunity to thank the Jim Bio for giving me the opportunity to share my experiences with the Ghana court case. I want to thank all the earlier presenters for what they have already expressed. They were very much on point. And so I am going to look at it. I'm trying to share my file. I hope it's there.
Yes, it is, Eric. We are able to see it. Please go ahead.
So I'm looking at it as a regulator who was deeply involved in the case in Ghana. Let me say that I assumed office as the Chief Executive Officer of the NBA with the court case. As soon as I entered the office, the case went to court. And I exited the office 2 weeks after the final judgment, 9 years later. So in all my career, I have been in court defending the technology and defending the regulation in Ghana. So I'll give a brief introduction and then I will talk about, I will not talk about the establishments per se, but the legal cases, some of which have already been expressed by the lawyers, and then the Ghana court case itself, and the lessons I learned. And I will give some recommendation based on the experience that I had as a regulator. See, it appears that when a regulatory body is set up and the law is being passed, you know, at the time the bill is being passed into law, there are a few turbulences. The situation may be challenged, but they are always able to go through. When the authority is in place and they start confirmed for trials, they are fine. Nobody challenges them. But as soon as our friends on the other side hear that that country or that regulatory body is about to commercialize or is commercializing, that is when the court cases start. And so if any regulatory authority in the region is thinking about commercializing genetically modified organisms or commercializing the technology in Africa, they must get themselves ready to go to court to defend themselves. So that is the situation and the trend that we have been experiencing. Elias mentioned the Kenya court cases, which they have been able to handle. But there's this interesting one when the government itself had to impose a ban on genetically modified organisms, you know, and it went for a long time until 2022 when the ban was lifted. So it is that serious. A court may challenge it, and a government, you know, if we don't navigate it, we don't manage it very well, can create a ban. So that is a very serious matter. And then in South Africa, Akile mentioned a number of, series of court cases, but at the end, you know, they managed to circumvent all of them. Burkina Faso did not experience any court case per se, but then there was this issue of quality of the cotton with respect to the fiber length, which led to a close down of the industry. And that created a problem. Just at the point where they were doing commercialization. And so they had to withdraw, you know, Monsanto had to withdraw, and then the whole industry collapsed. Even though in 2023, they started calling for the reintroduction of GMOs. So at that commercial level, the industry was able to collapse. So that makes it very important for any country engaged in genetically modified organisms, you know, to go by the law, as Vivian said, and take it serious. Egypt has its own problems. In 2024, the National Biosafety Committee had a legal challenge, you know, from a civil society group concerning some approvals that were granted without consultation. But again, they were able to circumvent it. And in Zambia, as Sandra may agree with me, in 2014, there was this lawsuit trying to block genetically modified maize. And the case was resolved in 2015, even though Zambia has not gone far in commercialization. But, you know, in a country like Zambia, there was this situation. Nigeria, as soon as they commercialized 2017, went straight to court. It was a very turbulent case, but, you know, the NBNMA managed to overcome it. Now, looking at the Ghana case, the case started in 2015, February, and it was, as Sandra said, headed by the Food Sovereignty Ghana, with backing from some 4 others, against the then National Biosafety Committee, which, in fact, at that point, Akile put it right, was transiting into the Biosafety Authority, because from 1998 all the way to February 2015, it's a committee. But on the 10th of February 15th, the authority was established. And so it was in the transition state. And the plaintiff got it wrong in the sense that they were saying the National Biosafety Committee did not have the legal right, with regards to biotechnology and biosafety matters. They did not have any legal right. They were wrong, and I will explain. And that in approving the release and commercialization of GMOs in Ghana, the NBC had not met the requirement on issues like risk assessment and risk management, which were wrong. And then again, they were claiming that NBC could not approve the release and commercialization of GMOs without adhering to the biosafety law. All these allegations or claims by the plaintiff were not on point, because at that point the Biosafety Committee was acting under the regulation LI 1887, which mandated them to approve issues for commercialization, issues for research, confirmed for trials, and contained use. And that was exactly what they did. And all the records were on commercial legal research, confirmed for trials, and contained use. At no point in time did they even dream about commercialization, because they understood the law that gave them that powers. And to say that the NBA cannot approve the release of commercialization on GMOs, was also wrong. And at that point, let me say that they were acting in line with the biosafety law, 2011, because in section 40, subsection 2, the law had adopted the LI 1887, which was passed before this parent law, because it says that until regulations are made to implement the law, the LI 1887 shall continue to be in force as if made under the law. So all that the committee were doing, approving research, were in line with the law. And so the basic claim by the plaintiff, were all on point. And so we had a way of responding with the assistance of the lawyers. I think I've talked about this. Now, what happened was that when the case went to court, the NBA responded, and we gave every exhibit to prove that the National Biosafety Committee was not commercializing anything, but we were just approving research. And that first information that we gave to the court in response to the claims of the plaintiffs opened their eyes, and they saw the mistakes they had made. And so they came in with supplementary affidavits, now stepping it further. And that was how the case became. Any affidavit they submitted, they were wrong. We put in our lessons, our responses, and they learned from the responses, and then they came again. It was like, to them, they had to go to court and win. And Akile put it in a very good way that some people makes it, makes going to court their business, you know. So no matter what, they are rewarded in going to court. And so all their responses disproving their claims in their supplementary affidavits that we made, they still found reasons to go to court. And at a point, as Vivian said, they were challenging the technology using the propaganda information that we all know all over, on internet. Now, these are the lessons that, as a regulator, having been involved in the biosafety legal matters, I got. You see, the prolonged legal battle, itself was raising awareness, even though it was unintentional, because when the case went to court and it was about genetically modified organisms, it attracted national attention and global attention. So everybody wanted to know what was happening in Ghana. And so it gave us the opportunity to explain. And it gave us also the ability to explain how the law works and how the regulatory aspect, under the law are executed. So in effect, the case going to court was good, and it was an opportunity for the regulator, to be, to educate the public, on the matter. I also learned that keeping records is very key. In biosafety administration, it is always good to keep records, and that saved us. Because at the point, the plaintiff wanted to convince the judge that there was no biosafety authority in place. It was when they took the matter to court that the minister or the ministry hurriedly put in place NBA. So it was the records that we kept that helped us, because see, the minister cannot get up and within 3 days or 5 days call people and inaugurate the board. Before it went to court, the organizations or entities cited in the law as forming the board were written to nominate their representatives. They took time to respond, but they all responded and the letters were received. The ministry gave itself time, to schedule the inauguration meeting. They wrote the invitation letters for the representatives to attend the inauguration, and the inauguration was held on 10th of February. The case went to court on 5th of February. The inauguration was on 10th of February. So we had to go into the archives to bring out all the communications to prove to the judge that the minister did not hurriedly, put in the authority or the board just because the full sovereignty and their allies had gone to court. So all these communications were submitted to court, and the judge was convinced. That's what I've already talked about. Something became clear, and I think it is not going to be so going forward. With all the statement of claims that the plaintiffs gave, they were exposing their ignorance. They did not understand the biosafety concept. They did not understand the technology. They were only interested in rushing to court just because they felt they had got something sensational. And they were dwelling on the easy public sympathies that they were getting. Because everybody, if you say anything negative about a technology, the whole public, run after you or run with you. So they were enjoying that. So there was this show of ignorance on the part of the plaintiffs, but the responses through, by the regulators explained everything to them, and they learned. It was a public education to them and also to the judge. I remember while sitting in the witness box, the lawyer asked me a question, which made me recall some of the details of the law. And I had the privilege of taking the notes at the time the bill was being written, prepared. I was a young man in 2000, 2002, the young man taking the notes for the lead drafter, Justice Crabb, to draft the law. So I understood very well the thoughts that went into the provisions in the law. So he gave me opportunity to take my time, calm manner, to explain the situation to the judge. And he interrupted by asking me that, Mr. Okore, I asked you a simple question. Why are you going into details? But the judge said, allow him to talk because he is giving useful information. So that is how our case was. And the ignorance on the part of the plaintiffs gave us the platform to explain the issues very well, in court. And they learned out of that. I would say that going through this case for 9 years, they are no more that ignorant. So as Vivian said, yes, of course, they will come again because Ghana is still commercializing, and they will come more informed. And the case is going to be more difficult than this initial one. So that is one lesson I learned. Public education is very key because it came out that even at that point, a lot of people did not even know that there was a National Biosafety Authority in place. And what the Biosafety Authority was doing. And they lacked understanding on GMOs, the technology and their safety measures as put in place in Ghana. And the judgment, in the judgment, the judge gave a condition to the Biosafety Authority to step up in public education. In fact, during the case, I realized that was a weak point. That was a weak point. We had not done much. But there is one thing about public education. You never finish. You cannot finish public education. You start, and then you sustain the effort. So we produced documents that convinced the court that, yes, we haven't done much, but we were doing our best, and we were still making the effort. So public education is very key because if the misinformation can be reduced, it is through public education. And every regulatory institution anywhere in the region should take that very serious. Transparency is very important. And the biosafety law, calls or places an obligation on the regulator to be transparent, apart from, technical confidential business information, which the regulator is not supposed to put out there. So we tried to be as transparent as possible. I remember when the case started in 2015, somebody from one of the plaintiffs, the Convention People's Party, which was the party Kwame Nkrumah used to gain independence for Ghana, they were, on the part of full sovereignty, challenging the regulatory institution. They sent a lawyer to my office asking for all the decision on the cowpea and the rice and the risk assessment report. I just stood up, opened the file, made photocopies and gave it to him. And if you remember, while the case was going on, there's this Center for Climate Change. They wrote to the NBA asking for some information. They wrote through Facebook. We responded through Facebook. Just because the law says we have to be transparent. And we did exactly that. So transparency is very key. And when you demonstrate to any stakeholder that you are transparent, the trust, is there. And so transparency is very key. And labeling was also one of the issues that the plaintiff brought about, that labeling, there is no provision for labeling, which was wrong. I mean, it was false. And that GMOs must be labeled. Yes, GMOs will be labeled, because before before I was called into the witness box, the Biosafety Authority had worked with the Food and Drugs Authority, which is responsible for labeling food in Ghana. And we had come out with labeling guidelines. And this is what happened. In the preparation of the guidelines, food sovereignty was involved, because Food and Drugs Authority, which was spearheading the process, met different stakeholders, and we met advocacy groups, and food sovereignty was involved. At that point, their representative in the case, whenever we went to court, Elvis Ajemenu was their representative, 2015, and he was my friend. So I remember those instances very well whenever we went to court. So I told the judge, when I was in the box, that at that time in 2015, it was Elvis Ajemenu, and he was involved in preparing this labeling guidelines. And then at the closing part, it was Edwin Ando, who was representing them in court. And at that point, Edwin was in court. So I pointed to Edwin that, my lord, this guy, Edwin Ando, represented the Food Sovereignty Ghana in the final adoption of the guidelines. And he made some useful comments which were taken on board. So we have the guidelines in place. So Ghana has taken a decision to label GMOs, and the guidelines is there. So the judge was convinced, based on that. And there is also the need for stakeholder collaboration. Biosafety and biotechnology is not just the business of the Biosafety Authority and the scientific stakeholders. It is the business of all the stakeholders. And so, as much as possible, when there is any case on GMOs in Ghana or in the biosafety biotech discourse, all stakeholders must be involved. We experienced a very bitter experience. We had a very bitter experience, and I think I need to share this, using this platform. The lawyer, Vivian, mentioned that the defendants included the Minister of Food and Agriculture, which was Food and Agriculture, which was a very key stakeholder. But throughout the 9 years, Minister of Food and Agriculture did not come to court. They didn't come. They didn't care. I went there, spoke to their lawyer. They have a sitting lawyer in-house. I spoke to their chief director, but they refused. And that was not very good, that was bad. We had other stakeholders backing it, the Ghana National Association of Farmers and Fishermen and others. They were backing. So I am using this, experience to highlight on stakeholder collaboration in matters of this nature. The system will succeed if all stakeholders come together and they follow a common point in line with the law. There is also the need, to adhere to the principles of science, in any court matter. One of the claims of the plaintiffs was that the NBC in those days did not stick to risk assessment. But that wasn't the case. I mean, it wasn't true. So in court, I had to go in with the risk assessment report and the signature forms of the risk assessors. It is very key. And the National Biosafety Authority, is serious with it. So every record on risk assessment, is kept. And so that was tendered in court. And GMOs, through the risk assessment and other interventions, go through rigorous, testing before they are brought out. And so when these things are brought out, the public tends to understand or appreciate the safety nature of the business. And so the NBA and the stakeholders with them must take time to educate the public in all these matters. And when there will be understanding, and court cases, I believe, will be easier to navigate. I think there is also the need for formal education and non-formal education. It's about time that schools in Ghana or in Africa begin to introduce biosafety. Because, I've had interactions with the elite in Ghana. And within the elite, you find people challenging the technology, disbelieving the effectiveness of biosafety. Even though they are scientists, but you can see that they just don't want to accept the technology based on what they have understood. I believe that if the formal system begins to introduce biosafety and biotech courses effectively, I mean, understanding will come up. And then again, non-formal education, should also be stepped up. Community forums, agricultural extension services. I mean, the officers being trained, to go out to talk to people, and the media campaigns, should be stepped up, because when these things are done effectively, court cases will reduce. You realize that the plaintiffs or our colleagues in the advocacy side go to court just because, as I said, they don't understand, and they know that the public do not understand, and so they easily get the backing of the public. But where the public is educated and can challenge them, the number of cases can reduce. My recommendations before I close, in mounting defense, I recommend that there should be strong collaboration between the NBA and the defending lawyers. And that was what happened in Ghana. Whatever information the Attorney General, lawyers, Vivian and her team needed, the NBA provided without stressing them. Vivian had my contact, I had her contact. She could call me at any time, even during weekends, for information, and I gave out. So there was that kind of communication. And as I said, whatever information the media team required, the NBA should not delay. I mean, the legal team, the NBA should not delay. Immediately, the information has to be provided. And then every witness that is needed in the case should be brought on board, because different angles of defense strengthen the defense. Different angles of defense strengthen the defense. So any witness that we feel will contribute to the defense should be resourced, to come on board. And again, I will recommend that in any legal matter, yes, there could be an in-house lawyer at the National Biosafety Authority or the National Biosafety Agency. But I will also always recommend that the Chief Executive Officer should be the lead witness on the part of the regulators. You see, because in my case, when I went to court and I sat in the witness box and introduced myself as the Chief Executive Officer of the Biosafety Authority, I could see that the judge gave me that respect, and the lawyer of the plaintiffs also gave me that respect. And above the Chief Executive Officer, there is no other expert or authority when it comes to the biosafety regulation in any country. So when the Chief Executive Officer takes up the defense and sits in the box as a witness, he commands respect, and every information he gives is respected. And of course, if he goes there and he goofs, it's going to be a big problem. But I don't think any Chief Executive Officer will commit that mistake. And again, it is always important to go to court or to carry along the press team. You know, the press must understand the court process. It is wrong for them to discuss the matter that is being handled by the court. But the surrounding issues, they have to understand and express it well, you know, in public. What I experienced was that every time after, when we started the case in 2015, every time after work in the evening, Food Sovereignty had already run to a press station, I mean, FM station, and they were talking about their propaganda over there. So our pressmen should be carried along so that they can effectively report. There is this issue. You see, the Biosafety Authority is a corporate body. And the corporate body, the law is explicit in saying that they can acquire movable and unmovable properties. I remember when we were discussing this during the time of the drafting of the bill, Justice Crabb made a certain statement which is not expressed in this law. He said, as a corporate body, the NBA can be sued and it can also sue. So, but in the law, it is not explicit that the NBA can be sued and it can also sue. But there is a separate law that says that corporate bodies can be sued and they can also sue. So what we have experienced now is the NBA being sued. My concern is that the NBA should know that they can also sue. And that provision should be exploited by the biosafety authorities we have in the region. They can sue. They are not there always to be sued and spend their time defending. They can sue. Because one day we went to court in 2015, and there was this group of people behind me. I was a person standing up, you know, introducing myself as representing the Biosafety Committee or the Biosafety Authority at that time. So when I did that on one of the occasions and I sat down, there was a group of ladies sitting behind me. You know, one of them said, aha, wicked people, thieves. You have gone to take bribes from Monsanto and you want to sell Ghana. God will punish you. You are all thieves. You know, and she made sure that I heard it. She was saying it to me, you know, and it was, I mean, it was not so, you know. And then again, if you search internet, you will see one of the publications that came out. Okori lobbies for GMO promoters. I did not lobby it, but even right now, it's on the internet. I remember I went to a certain forum, and one of the food sovereignty representatives made a statement. He said, the GMO eagle has landed, You know, the GMO eagle has landed because Okori is eagle, you know, so the bird GMO eagle has landed. And there were some damning comments from the opponent side, you know, against the biosafety authority, you know, which could serve as a cause for the NBA to also go to court. So what I'm saying is that whenever an opportunity presents itself for the NBA to sue anybody, they shouldn't hesitate. They should sue. In closing, let me use this opportunity to thank these guys who helped us. The legal team from the Attorney General's office. In fact, it started, the lead defending lawyer was Mrs. Grace Ewell, but later Mrs. Vivian Opukwe Jakwa, you know, took over, and then Maud and the other long lawyers who went to court with us. They were fantastic. 9 years they stood with us. This team at the NBA was so strong. And I could see, on several occasions, whenever we close from court, they would just walk. We would chat out of the court. They would give me advice. And Vivian told me that Mr. Corey always stick to the law. Do what the law says. In the area of public education, try and strengthen, because if they will go to court, it will be in public education area. So go and strengthen it. So it was Vivian who, you know, as she said here in her presentation, drew my attention to always stick to the law. And that was exactly what we did. I want to say a very big thank you to them for helping us. At a point, I felt that, no, they have been very resourceful and useful for us. And so the NBA should be able to appreciate what they were doing. So I told Vivian, we will appreciate you, okay, in the course of time. You know what she said? Mr. Okori, we don't need anything from you. We are paid as government lawyers and we are doing our job. So don't worry. What we need probably from you is that anytime you hear that there is any biosafety training anywhere for lawyers, nominate us so that we can benefit from the knowledge. That is the only request Vivian made. So Vivian, thank you very much. I also want to thank NEPAD. When we started the case, it was NEPAD. You know, I was alone, one man who had been employed to serve as the chief executive. I was alone, and that was when the case went to court. And so NEPAD, I will mention Mr. Samuel Timpo, I will mention Akile, I will mention Mr. Godwin Lemgo. These were the guys who helped us to respond to the claims that the plaintiffs made in their affidavits. They helped us, you know, with information and materials, you know, to support the NBA, you know, in the defense. So I want to thank NEPAD and the team. I also want to thank Program for Biosafety Systems, PBS, because from day one to the last day, Dr. Daniel Ofosu and Professor Al Hassan, they were always behind us in court. They always came to court. They motivated us. They urged us on from the beginning all the way to the end, and they stood with us. I want to thank them so much. And then the media guys who probably are not in this forum, I want to thank all of them. In closing, I will say that I benefited a lot. If anybody asks me what benefit I gained, you know, in exiting office as the chief executive officer, it was the knowledge and the experience I gathered through the 9 years of the trial. I was grilled. I went into a lot of stress, trauma, and I was able to sail through with the support of these guys I've mentioned. It was a huge experience. So I walked out with this kind of experience behind me and in my head, and that is what is keeping me going. And so I want to thank all of you for this opportunity, you know, to have this interaction with you. Thank you. Zekomo, Sandra.
Well, thank you so much, Eric, for that elaborative presentations. I'm sure we have a lot more to take home with us. Issues of public engagement, education, strengthening the education, the regulatory aspect, also making sure that they educate the masses, and much more. Maybe at this point we can ask some questions to the team. There are questions in the chat, and there are also questions in the question and answer section. Maybe we can start with the one from the question and answer, then we go to the chat. So there's a question. Okay, this one we answered. The next one is, hi, Sunday and Vivian. Thanks for the presentation. It appears most litigation are procedural, and why the fights if the GMOs are safe? Is it intentional? Maybe we can take two questions, and then we answer, and then we go to the next one. Then the next one is, one of the key issues that propagandists try to whip people along has to do with safety. However, court feelings try to use the regulation issues, but other things are added, as in the Ghana case. Question, is there any health issue court case in any part of the world? How is AU helping institutions educate the public on GM, since Agenda 2063 adopts biotechnology as its important tool? Maybe we can take these two and then go to the, oh, there's one more. Maybe we finish the three from the chat, and then we go to, we finish the three from the question and answer, then we go to the chat. The last one from the chat is, thanks to the presenters for the excellent presentation on the cases. My question to the lawyers, what can be done to shorten the period for the court cases? We can take these questions for now. Thank you.
Okay, should I start?
Yes, please. Yes, please. You can go ahead and start.
So I'll take it from the procedural angle one. Somebody asks, it looks like the cases are mostly procedural so far. What I can say with the Ghana one is, yes, it is true. Because for us, you can, the plaintiff did not even come, as I said, did not even attack the technology. For Ghana, the government had taken an initiative to have this technology for the economy. So it has put in place policies and laws. So if you want to attack that one, then you have to move it to maybe our Supreme Court and say it's unconstitutional or something. But they know they have no feet or legs to stand on that. So they will attack the processes that are in the law as to whether the regulators have followed through or otherwise. That is the only place they think they can get us. That is why they went that way. And the issue about shortening the court processes, sometimes it is a bit difficult, because as I said, in our case, when the issue came up, we thought it was a very simple case. I mean, what is so hard and fast about breaches on the regulations? It shouldn't take us 9 years to go through this. But then you should know that when we go to court, it is not only one side. The other side also have the agenda going forward for them. I think one of the injunctions that this plaintiff brought, when they lost, they went to the Court of Appeal and lodged an appeal there. And the appeal was just sitting there. So at a point, we had to go to Court of Appeal, say, let this appeal process go through, because it can shorten the case. But the Court of Appeal said, we also have rules. We can't force them to just pursue the appeal when they are not moving on with it. So there's so much we can do. We do try and shorten it, but sometimes the processes are such that you can't just move it. And these guys they thought they were smart. They decided to go to the Human Rights Court. And in our case, if we say everything is human right, they give another notch to it. So the judge will have to ensure that we are going according to the processes. They don't want the cases to be overturned on appeal to say that they didn't follow through. So that is a question. I will do that. But after Akile answers, I wanted to come on to something Mr. Corey said on the corporate body. So when we are done with these questions, then we'll come back to it. Thank you.
Thank you, Vivian. I saw Sunday, you're about to say something. Please go ahead.
Thank you, Sandra. Thank you, Vivian. Actually, you've quite said just on the spot about the option for these groups to go for processes other than challenging substance of the law and so on, because the law is clear. Okay, like you rightly said, the Ghana case, the Kenya case. Once you get to challenge the authority is a creature of law, and you cannot undo the law. The court cannot undo the law unless it's an interpretation of so. If there is an establishment like an NBA by an act of parliament, the court is not there to rewrite what the parliamentarians have done. The court will not. The court will interpret it and uphold that. And for anything, normally the agencies are put in place to discharge certain functions. It's not the court to do their functions unless it should be always stretched to the latter or to the limit and seen that they have failed to do their functions. Then, so these groups will never challenge it because the laws are always there. The laws are tight. They will always look for omissions, flaws in the processes, like Eric said. And also they will not get on to challenge the science in this technology, because this is science that has been tested, that is science that has been peer reviewed in many respects. I know they also know. When you now talk about the technology of BT cotton, bacterial stulgensias cotton, so forever, whatever, for habitat, all this is science, technology that has been there. Who has challenged it? So they will instead go on your neck once they see you omitted to do this during a regulatory process, or you did not do this, or they sometimes even allege falsehoods to just test your ability to defend. But if you rise up like what Eric has shared with us, I think you can always overcome. The other question was about how to educate the public. He's trying to ask us, this is Mr. Kofi, is wondering what AU is trying to do in order to support Agenda 2063, given that biotechnology is a part of the development agenda has been adopted by member states. Yes, I mentioned the Freedom to Innovate report that was released by the late Prof. Callistus Juma and his team. That is the panel of experts. That report suggested many things. Actually, in that report, where it did approve that biotechnology, once used safely, can mean a lot towards the socio-economic transformation of Africa in the field of agriculture, in the field of health, and in environment, as I mentioned. But it went ahead to suggest that there should be cooperation among states. And it very much promoted regional collaborations, meaning there should be the Southern Bloc, there should be the Eastern Bloc, there should be the West African Bloc and the Northern Bloc. And it went ahead to assign certain key areas of interest for these regions. I think the Eastern Bloc was to have, among others, focus on animal biotechnology. Southern Bloc, which is the Southern African countries, were to, among others, they can do other things, but they should have focus in the area of health. And I think West Africa was to have a focus on crops. Then North Africa was on pharmaceuticals. That is the kind of collaboration. And why did it suggest this regional collaboration? Is because it did recognize that Africa has its challenges in terms of resources, capacity. So having a hub for a regional collaboration would quicken the portability of data from one country to the other. Probably some of the regions have the similar ecological conditions that they can even conduct research together. They will utilize the most strategic resources at their disposal adequately without any costs, and they will share their capacities, the human capacity. So this is the way African Union has designed the way member states should collaborate or cooperate in order to be able to tap into these vast benefits that the technology can always present for member states or for the continent. And of course, the emphasis, it should be done safely. The other question is, what can be, oh yes, about the courts take, yeah, Vivian has rightly said, I tell you, the Ghana case taking 9 years. The other case in Kenya, the one filed in 2015, was there for all the years until when these others came, then they all came on board, activated, and so on. Now, the courts, the operation of courts is pretty the same across the continent, even all over, not only here, even in other parts around the world. Why? Because courts have their diaries to manage. Individuals also have their diaries to manage. Then also, the judges have certain diaries to manage. You find some judges disposed, judges find leave, but taking 10 years sometimes is quite, that to me, it was long enough. Also note that sometimes judges get changed, others are dropped, others lose their jobs. I think in Ghana, one judge caught himself in a scandalous, who was involved in the case, it got into a scandalous kind of behavior that disqualified him even from, I think, the bench. So that kind of arrangement always leads to cases taking their time, but also there are cases that can be fast-tracked depending on the judicial officer who is available and also the interest of the parties, especially the lawyers. Lawyers have a tendency of delaying tactics, especially those who have interest of delaying are those who go for conservatory orders. Once they run to court and those orders are granted, they go to sleep. They will never follow their case seriously. So that has always been the habit in many, many countries. And it's a very, very tactful behavior, which is very unprofessional, but that is very unfortunate. It happens. But where judges will take things seriously, I must salute the judges in Kenya. I think the last 3 years we've really witnessed things move very fast, and they have lived according to their fixed schedules to handle these cases. I think, to me, it was a very, very good example to other jurisdictions across the continent. Others, with that, thank you very much. I thank you, Eric, for really recognizing our contribution towards that case. And it moved me as you are saying that, that to me meant so much, because the very fast response to that case, I think I penned it while I was in an hotel in Zambia, Lusaka. We were on a mission with this Godwin and Sam. And it was then taken up from there by my learned colleagues, the Vivians and the others. So we thank you so much for all those efforts, and I'm very, very happy, proud of the outcome in Ghana. Thank you.
Thank you so much, Sunday, Vivian, for the responses. We have 2 more questions before we can close. One question is from Peter, who is asking, are there any ideology behind the scenes fights to deny Africa advanced technologies and some global forces ensuring that Africa's agriculture remains stagnant? That's in brackets, full of biotic and abiotic masses. Then, so that Africa should remain dependent on them regions for food. Those so-called, sorry, I think my mouse is moving fast. Just a moment. The so-called plaintiffs from, I'm sorry, I think it's cutting from this end. So that question from Peter, let me just read it again. Sorry about that. Okay, it reads, My question is, are there any ideology behind the scenes fights to deny Africa advanced technologies, and some global forces are ensuring that Africa's agriculture remains stagnant, so that Africa should remain dependent on other regions for food? Those so-called plaintiffs are from NGOs whose agenda is to secretly work for the global chemical industry, as most GMO plant technologies replace pesticides. Look at Burkina Faso case. Look at the BT cotton, maize cotton, cowpea resistant in Nigeria and Ghana. These, when adopted, lead to reduced pesticide sprays. Lastly, is the Center for Biodiversity in South Africa providing an alternative to DT maize solution to South African farmers? Or are they sadistically enjoy to see farmers suffer? Then the next question is, thanks, Eric, for your presentation. I like the introduction that highlights all the court cases and the wins that we've had. This is the information that stakeholders need, and so this information should be shared widely among stakeholders and the media houses, so that we should show that the regulatory bodies know what they're doing. Okay, this is a comment from Madam Tibor. Then I think we can go ahead and respond to those questions. For the presentations, I think we will need to get to Gene Bio. We can go ahead to respond to those questions before we conclude. Thank you.
Yes, the question that is trying to have an opinion, I will not really say much about that opinion, whether there is conspiracy to keep Africa probably aback, not to catch the pace of advancing technologies. Yes, for those who read on the wall, will state clearly that much as Africa is still struggling to deal with a conversation around biotechnology, the world is not waiting for Africa. We are now talking about genome editing techniques such as CRISPR-Cas, so many things. The advance, the speed is so terrific. But we are here still talking about biotechnology, refusing and refusing. But at times also the refusal, to me, at times selective, whether those who refuse really know. Because when you tickle them around health, they don't even want to talk about it. Health advances of the technology in health, medicine, they don't. But when you talk about food, agriculture, crops, it's quite an intense debate. Now that is something I leave for us to conclude. Or my conclusion may not be as good as yours, but let's educate our population. Let's educate the African public. Eric rightly said, let's have this in our curriculums, in schools. If we speak, we introduce all this, children will be growing up knowing that technologies can be used to improve the lives of humankind and even the surrounding in many ways. So I think we need education. Unfortunate that those who even were educated, who are scientists, some also rise to oppose, but it's quite unfortunate. Let me end there. I don't have not much to say. The other comments I've seen, I think I appreciate. The one who says she loves hearing from other African countries. I didn't know what exactly she meant, but I don't know whether the cases, the stories about the other African countries. I think the momentum across the continent is high, a very positive momentum towards adoption, conversation. Countries are putting laws, countries are beginning to have their conversation. First and foremost, there are only 3 countries out of the 55 African countries, only 3 that have not ratified or acceded to the Cartagena Protocol. That shows how positive African member states are. The only 3, I think the 3 are one of the Guineas, I'm not certain which exactly, then Sao Tome Principe, and then South Sudan. Those are the only 3 countries that have not, meaning all the others are parties. Now, if they are parties, with that being a party to the protocol comes a condition that you have to domesticate the instrument in your national legislative system. So if countries can go further to domesticate, meaning to put in place regulations that are functional, then it will be attractive to prospecting investors who can come and invest in the technology to be able to get good results to better the lives of our people. That's all I can say. Thank you.
Thank you, Sunday. Is there any of the presenters that would like to respond?
Yes, but I wanted, Sarah, I wanted to say something a little about Mr. Corey's admonishment and recommendation on the authority being sued and to also sue, if I may, because I'm moving off a little. Is that okay?
Please go ahead,
Okay,
Vivian.
okay.
Please.
So using the Ghana example, for Ghana to be a legal personality, that is somebody you can sue or be sued. It can be an entity, an authority, but it has to be in your enabling act. So you can be a body corporate, but if your enabling act does not say you have to be sued and be sued, you cannot be sued. So that is one clarification I wanted to make, because even the ministries that were joining our suit, they didn't have personality, but they were there because of the Attorney General, who is more or less the nominal defendant for all of them. So going forward, if the NBA wants to sue and be sued, then they have to do something about its act. Otherwise, you cannot take your own matters to court. That is by the way. And then on the issue of the judges, and especially in handling of some of these suits that prolongs the matter, we had 5 judges. Unfortunately, Akile, 2 of them passed on, and then the other 3 continue. So it all added to how the case went from one judge to another judge, all in the High Court. Now it is separate from the ones that went to the Court of Appeal and the Supreme Court. But we realized that the 5 judges that we went before them, there were a different level of knowledge on this technology. So my recommendation would be to the capacity building should not be for only the lawyers, but the judges too, they need it. Going forward, if we have some of these cases coming up, it will be very useful that a judge who is informed about this technology will be the one to sit on our case. So I propose that anyone, Jinbai or anybody, if you are interested in doing capacity building for judges, it will be great. And I'm sure if you approach our judiciary or any of the sister countries' judiciary, they'll be willing to take on board your suggestion. I thank you.
Okay, thank you so much, Vivian, for that. We will now give the presenters at least a minute for the takeaways to wind up before I call upon Dr. Willie. So I will start with Vivian, since you were just speaking. Maybe you can go ahead, Vivian, and then we'll follow with
Sandra,
yes,
I just gave you my closing remarks.
Okay, that's great.
The take home is about capacity building, and the education bit is also critical for us, so that the populace will be aware of what the technology is about and the laws backing them. And that one lies squarely with authorities to up the education bit. I thank you.
Thank you so much, Vivian. Now, Sunday, then we'll have Eric and Elias before I call upon Dr. Willie. Thank you.
Thank you very much, Sandra. Thank you, all of you, our panelists, the participants, for your patience. And I've seen them. I'm very happy that we're taking keen interest in following what is happening on the continent. There are many issues that will still remain in the picture as we keep on going on with the debate. I just see one question here again from Saba Zahara. She's wondering whether my understanding is whether seeds do not exchange hands, and I think that has been one of one point of the debate, that as Africans we are used to keeping seeds, so the seeds will not be stored, seeds will not be kept, you cannot pass seeds to own. from one family to the other or from another home. Now, there is a lot about conversation about the seed system, the seed industry, even to date. Even the seeds that you say we are having, some have lost their viability. Hence, you find our research institutes, the Zaris, the Kalis in Kenya, the Naros of Uganda, the one in, I think, Sari in Ghana. All those, they are always trying to improve the seeds. Those conventional methods, they're improving hybrids. So once the hybrids are improved, they end up in seed stalls, unless they are subsidized by governments so that they can pass on to farmers. If it's not done by government like that, you will end up lining up to buy seeds. I think this has been part of us. It's always hyped up to say that the seeds will be hidden, seeds will be patented. It is just within the seed system, and that is capitalist economy or a liberal economy that you may call it. So to keep on to that as a concern, I think, to me, it becomes quite obsolete now, because it is very much part of the human life that we have to buy seeds every season, because seeds that are always stored in other manners are never viable. So this is really what I can say, but I'm very happy. I thought what I've shared my presentation with the Gene. I think the organizers will share, and I'm very happy. Look forward to having another meeting like this with you, and we're always happy to associate with this kind of conversation that speaks for the greater good of the continent. Thank you.
Thank you, Sunday. Eric, is Eric still? Oh, yes, Eric. Then Elias, thank you.
Thank you very much, Sandra. And I want to thank everybody for the attention.
Sorry.
I thank Vivian for her correction on the corporate body privileges when it comes to suing and being sued. Thank you so much, Vivian. As a regulator who tasted what it is to go to court, I would say that every regulator should bear in mind that at a point in time, he or she is likely to go to court. So we must get ourselves ready. And the best strategy to get oneself out of this situation is to follow the enabling law. The law and the guidelines create the pathways, which the regulator has to follow. And so when you follow the law, you are fine. Let them take you to court, but you did the right thing. And so you'll be able to defend yourself. And so I want to stress on that. I also want to stress on public education. It is very important. All these things hinge on lack of information. And so if the regulator does the public education effectively, he is likely to escape most of these things that cause the stress on them. The laws are very clear that the regulator should educate the public on activities under the Act. So we should not delve into the technology and defend the technology. Let us educate the public on how we implement the Act and how we make sure that safety is there. Thank you very much, Vivian, Sandra.
Thank you so much, Eric. Elias? Elias, are you here with us? Indeed, the future of the technology lies in the hands of those that have the right information. These could be the communicators, the researchers, the scientists, the regulators, and it is important that this information is shared with the masses to help them make informed decisions. This can also help in terms of, I think, reducing the number of litigation cases, because if people have the right information, they will be able to understand, and before they take other steps, they will have the right information. I would like to thank everyone, the presenters, for your time, for the presentations that were on point, and we've learned a lot. I also want to thank the partners and also everyone who joined in for your time to be in this webinar. The questions also opened our minds, and we also have a lot to learn and also something to share at the end of the day. The organizers too, it has been a great time. I now call upon Dr. Willie to close the webinar. Thank you, Dr. Willie.
Okay, thank you, Sandra, for taking us ably through the webinar. Are you hearing me?
Yes, Doc, we are hearing you, or at least I'm hearing you.
Yes, I want to thank the presenters most sincerely for the insightful discussions and presentations that they have given us. Thank you, Council, Vivian and Elias. I know Elias had to drop because I think he has some other issues. We were not able to have our senior counsel from Nigeria, Igbogu, because he had a court case. And I'm sure he'll be joining us in future. Eric, thank you so much for that insightful acknowledgement of what really happened and how you are able to navigate through those challenges. I believe the regulators who are on this webinar have learned something from you. Everyone, if you need any presentation, we are going to share the link to this recording, hopefully by Friday. And we'll do that through our website and also through our newsletter that we send out on every Friday. So if you are not a member of our newsletter, please make an attempt of registering. And I've given you email to do that. We also have vibrant WhatsApp groups that if you want to join, you should send us an email and we'll be able to put you in one of the WhatsApp groups that you are capable of joining. This webinar was planned with the help of Auda NEPAD. And I know Akile was supposed to tell us how they are capacity building the lawyers. And as a consortium, from today, we are going to have a platform for the lawyers together with, in collaboration with NEPAD. And we'll be reaching out to our legal experts, to join this platform. Also, it's up off, eh? Oh.
No, you're on. We can hear you, Doc.
Okay, sorry, my computer went off. So we'll be reaching out to our legal experts so that we can start this platform very soon. So with those few remarks, I want to thank you all, and please let's keep in touch. Please follow us also on our X platform because very soon we are going to have Twitter Space discussion on some of these issues. Thank you so much, and may God bless all of you. Bye-bye for now.